Hi everyone, Harry here to talk about the latest reversal of a district court at the Court of Appeals level. Remember, I've tried to emphasize that while we're attuned to thinking about who appointed what judge, it might well be that the more important dynamic is district court, where Trump has been taking his lumps left and right almost invariably, and courts of appeals and even Supreme Court, which should be more attentive to what they see as abstract principles of executive power and not wanting to hamstring the executive and sort of constitutional general principles and the like. So we have a Maryland District Court judge, Judge James Breedar, appointed by Obama. And this is one of the cases involving probationary employees. So when the Trump guys came in, they just totally lowered the boom on these so-called probationary employees who have yet to achieve the year to 14-month status that kicks in the kind of whole permanent panoply of remedies under the Civil Service Reform Act. And that was their initial target. But they do have these probationary employees. And by the way, it doesn't mean they're new. If you go to another job within DOJ, you may become probationary again. You may have a really important role in the department. But anyway, that's been a common first order of attack for the Trump people. And so there's been a number of challenges to them. And what happened in this one, this has also been a common refrain, as is the rationale. We're going to see this playing out in different kinds of cases. But this is one of the cases, there are about 3 or 4, brought by Democratic attorneys general from like 19, 20 states altogether. That's an important point generally because as we look to the Trump largely successful enterprise of taking control of the Senate, of the House, arguably the courts. When you look at the sort of final weapons on the field, one of them is state AGs for certain. And this is one that happened, but that's always going to entail. We saw some of this with Republican AGs in the suing in the Biden administration, issues about standing. So you guys, I think, have a sense of standing now. Do they really have, the plaintiffs, whoever they may be, a stake in the game? Have they personally been hurt? And you can see just off the top of of the facts that they're suing and contesting the discharge of all these probationary employees, and yet the injury to the employees is not the same as the injury to them. That is all true, and it's also true that there is a process in place, including under the Civil Service Reform Act. It's less muscular, but still there for the probationary employees, which is why they're not suing. The state AGs, however, argued successfully in the district court, we've got standing because before anyone does this, because we have a stake in some of these things, we're supposed to get notice from the federal government. We got none, and a few other sort of theories for why they personally are hurt. The district court accepted that process-based standing claim, failure to get process that the law guarantees you can, in fact, be a valid injury for purposes of standing. But it now went up to the Court of Appeals, the Fourth Circuit that sits above, and in a kind of party line vote, it went to the Fourth Circuit, and 2-1 they held, no standing. And the dissenting judge, a Democratic appointee, said exactly as I've just explained. They do have standing because of process, etc., but the majority disagreed. And when you think about how that plays out in the context, as we always are having now, of these emergency motions. Emergency, says the administration. You're telling us we have to reinstate these employees, which is a terrible development. And so the Court of Appeals agreed with the U.S. that there isn't standing here. And then you can see that kind of reverses the whole dominoes, because if they find there's no standing, then what the district court had considered as the sort of first prong of an emergency analysis, likelihood of prevailing, It said yes because it looked at the law having found standing. The Court of Appeals now, having disagreed and saying these Democratic attorneys general don't have standing, now they can assert under that view that the administration is likely to win on appeal because they're going to win for lack of standing. And now the whole emergency analysis flips over to them, to the administration. The dissenting judge did say not simply is there standing here, but there are other problems with what the government is trying to prove. The majority went the other way. So it's a dynamic. You know, there are different things playing out with the probationary employees. They will, by the way, all these people discharged, they're going to have to go under a civil service regulatory regime and then to the courts. They're going to wind up costing taxpayers millions of dollars because their rights were violated. Just not here because it was the state AGs that are suing. So that suit won't go forward, but it doesn't mean that the probationary employees aren't right and won't get remedies. They're not necessarily reinstatement. But the standing argument is going to be cross-cutting because there are a number of different cases in which the Democratic AGs have tried to challenge different moves by the administration, and they've got the litigating force and litigating chops and the wherewithal to do it. So there are going to be these battles over standing. This is one that ends in a finding of no standing. Others could end differently and have to be resolved by the Supreme Court. But the main thing to point out here is it doesn't mean that the probationary employees were properly discharged. They weren't. They just have a process they have to go through. It might mean that it's much less likely for them to be reinstated. Remedy is always going to be a separate thing here, and I think courts of appeals may be tougher on that, the way I've said district courts are. But this is one in which it's an ongoing battle, even though there are different facts in different cases where Democratic AGs have come into challenge, always provoking a standing argument. And here at the Court of Appeals level, anyway, they win. And so the district court opinion and TRO goes away. But both the issue and even the standing arguments will be playing out elsewhere. So it's not the end of the issue, and certainly not the end of the world for probationary employees who are still going to get a remedy, just possibly not quickly and possibly not being reinstated. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.